Good afternoon, everyone, and thanks for joining us for a Tax Practitioners Board webinar. My name's Julie Shaw, and I'll be hosting today's session. I'd like to begin today by acknowledging the traditional owners on the land on which we meet. In the spirit of reconciliation, we acknowledge the traditional custodians of country throughout Australia and the connections to land, sea, and community. We pay our respects to elders, past, present, and emerging. We extend that respect to all Aboriginal and Torres Strait Islander peoples today. Now, just to begin today's session, I've got a couple of housekeeping messages that I'd like to share with you. First of all, to access our slides, you can just jump onto our website and visit our webinar resources hub, and you can locate that at tpb.gov.au/webinar-hub, and you'll see the address there on the slide. And I'd also like to let you know that we will send you an email after today's session, which has a copy of the slides and also some helpful hyperlinks. And the final reminder is that we will also let you know that this is counting towards your your continuing professional education, and you can claim 1 hour for attending today's session. So let's have a look at what we're going to be covering off on today. So today's presentation focuses on client instructions and authorisations. So in particular, what we'll be looking at today is what client instructions and authorisations are. We'll have a look at some engagement letters. We'll also look at managing client money and property. We'll talk about trusts and when property is held on trust. We'll talk about how to hold and return money or other property that you do hold on trust. And then we'll also talk about liens, and we'll also look at some other important matters to obtain client authorisations about, and that includes disclosing client information to third parties, outsourcing or offshoring, and also we'll take a look at managing conflicts of interest. So then to finish up, we'll answer some of your common questions that we do receive during the webinar today. And in that regard, we've got 2 of the TPB policy and legislation advisors online with us. So we have Fiona and Daniel online today, and they'll be responding to your questions. So just make sure that you send them through via the chat box today, and we'll get to those as we go through. Next, I'd like to introduce our speaker for today. So we have TPB board member Deborah Anderson on board with us. And Deborah, I just wanted to welcome you to the session, and I'll hand over to you so you can kick off the presentation.
Thanks for having me, Julie. It's really great to be here today. And thank you to everybody for joining us. I can see we've got close to 2,500 people online. So what a great turnout. And it's a pretty heavy topic. So, bear with me today. As Julie said, I am going to talk about client instructions and authorisations with you. It's a very important topic and a conversation that we should all be having with our clients to ensure that we have a mutual understanding of the terms of our engagements, and also to ensure that we are meeting our obligations in relation to the Code of Professional Conduct. So let's get started with a quick overview of what we mean by client instructions and authorisations. Obtaining your client's instructions is the foundation of your engagement and the relationship with your client. It's important that you determine your client's expectations and have a clear understanding with them about the scope of advice or assistance you will be providing, or just as importantly, not provide. And this helps to avoid any misunderstandings with your clients. Further, seeking client authorisations is a simple way to ensure that you comply with your requirements under the Tax Agent Services Act 2009, or the TASA for short, and the Code of Professional Conduct. There are a number of relevant items under the code that we will touch on today. And importantly, client authorisation gives you the authority to act on your client's behalf. So although not mandatory, we highly recommend using engagement letters to clarify your engagements and establish a mutual understanding between you and your clients of expectations and responsibilities. An engagement letter serves as the starting point in an ongoing relationship and the communication between you and your clients. So why use an engagement letter? Some of the key reasons to use an engagement letter are that they're a really useful tool to help you maintain an efficient, effective and ethical practice. They set out the terms and the scope of the professional service that you will offer your client. They create a clear understanding of the various elements of the engagement between you and your client. And engagement letters are also a simple way to set out your business practices that you have in place to ensure your clients and you comply with the code obligations. Engagement letters should inform your clients about their rights and obligations, and they're a useful reference point in the case of future questions and around the expectations in your relationship. And most importantly, engagement letters help avoid uncertainty and misunderstandings, especially in relation to things like in relation to disputes over fees or scope of work to be completed. So, and often in many of the complaints that we get here at the TPB, often those complaints come to us because there was no clear understanding at the very beginning about fees or scope of works to be included. So highly recommend those. Some of the things that an engagement letter may include are the description of the work to be completed, and that could cover things like who will complete the work, how will the work be done, when and where will the work be done, how much will the work cost, and you can break that down. It could be how your fees are calculated. Is it by hour? Is it a fixed fee? The frequency of the billing, and the time frame for payments. It could be 50% up front, 50% upon completion. It could be upon lodgement. These are the things that if you include them in your letter of engagement, it helps limit a lot of the common disputes about fees later on. Engagement letters should also talk about how you manage your client's information and maintain the confidentiality of your client and whether their information will be disclosed to third parties. And I'll talk about that a little later. The engagement letter should also include information about arrangements you have for storing your client's documents or making copies of them. And we recommend you include information about your responsibility to provide services in a competent manner, within agreed timeframes, and including lodging the documents with the ATO. It's also a good idea to set out in the engagement letter how you will deal with tax refunds if you receive those on behalf of your client. So if you plan to deduct your client's fees from a refund, you need to obtain their consent. And it's important to know that all refund money should be passed on to your client. Our guideline is within 2 weeks. And Julie will send you a link with some further information on that after today's webinar. It's also important to include your name and your agent registration number in your engagement letter. And this gives certainty to the client that you are registered with the TPB. And if you like, you can also put your registered tax practitioner symbol on your engagement letters. And the registered tax practitioner symbol it's designed to be a visual recognition that you are registered, that you have met the eligibility requirements, and that you are obliged to meet appropriate standards of professional and ethical conduct in providing services to your client. And all registered tax practitioners who meet the eligibility criteria can use this free symbol. And Julie will send you a link to the instructions on how to download your symbol after today's webinar. Other information you can include in your engagement letters. A really good one is the client's responsibilities to you. So it's not just one way. And their responsibilities could be things like to make relevant information available to you in a complete and timely manner. They need to advise you of changes in any matter that is relevant to the services that you're providing, and also letting them know of the consequences of errors and omissions in the information given to you, or in the case of omissions, not given to you. You can include your duty under the Tax Agent Services Act to act lawfully in the best interests of the client, and to act honestly and with integrity. You can also include your arrangements on how you manage conflicts of interest, such as if you represent spouses or entities, different entities in a partnership arrangement or trust arrangement. You can also use your engagement letter to disclose commissions that you receive for referring or purchasing products or services that you recommend. That could be software, financial services, loans, etc. And a common complaint that we see here at the TPB is about possible conflicts of interest following a marital breakdown. And I'll go through an example a little later, but you know, it's really important that you identify all these processes up front. And of course, the rights and obligations of the client under taxation law. So, for example, if the agreement is for the preparation and lodgement of tax returns, the agreement could advise the client of the self-assessment system and of their rights to objections and appeals within that system. So now we're going to take a closer look at how you should make, just a moment, Hugo, stop. Sorry, everybody, that is my dog. On how you should manage your client's money. I'm sure you're aware that registered tax practitioners are bound by the Tax Agent Services Act and the Code. And the Code establishes a set of 14 ethical and professional standards that all registered tax practitioners must meet and continue to meet in order to remain registered with the TPB. I'm so sorry. Hey, stop. With regards to today's topic, I'll begin by focusing on code item number 3. And code item number 3 states that if you receive money or other property from or on behalf of a client, and or you hold money or other property on trust, you must account to your client for the money or other property. So money or property received on trust can include things like money held or received in advance, and that could be to settle or meet future liabilities, you know, subject to the terms of a retainer. It could include client tax refunds, or it could include monies paid to another tax specialist for seeking specialist advice. To comply with code item 3, you must keep money or property that you hold on trust for a client separate from personal money or other property. You must only apply the money or property on trust for the purpose for which it was intended, and for the purpose that it was intended, but also that you have the authority to hold. You must maintain records for all money or property held on trust, and you must comply with all laws and regulations relating to the custody and accounting for assets. And importantly, only disperse money or other property held on trust in accordance with express client instructions or as a requirement by law. You should pass on refund monies to your clients promptly. We expect that any refund monies that you receive on behalf of clients should be passed on to them within 2 weeks, unless there are exceptional circumstances or an express agreement between you and your client specifying other payment arrangements. Now we'll talk about trusts, and trusts are quite common, however they are frequently misunderstood. So let's have a quick look at the definition of a trust. So put simply, a trust is a relationship which exists where A holds property for the benefit of B. And A is known as the trustee and is the legal owner of the property, which is held on trust for the beneficiary, which is B. 3 elements are required to make up a trust. So they are the trustee, the beneficiary, and the trust property. The trust can be an individual, it could be a group of individuals or a company, and there can be more than one trustee and there can be more than one beneficiary. Where there is only one beneficiary, the trustee and the beneficiary must be different if the trust is to be a valid trust. While the trustee is the legal owner of the relevant property, the property must only be used for the benefit of the beneficiaries. And the trustee will have a legal title to the trust property held on behalf of the beneficiary, but will be limited to acting in relation to the trust property. Acting in relation to the trust property for the benefit and in accordance with the agreements that created the trust. So in this sense, a beneficiary also has an interest in the trust property, and this interest is referred to as an equitable interest. A trustee owes certain duties to the beneficiaries of the trust and has certain responsibilities in relation to the trust property. One of these is the duty to account to the beneficiaries for money or other properties held on trust. So from a TPB perspective, when is property held on trust? So property will be held on trust where an entity, and that could include a registered individual, a company or a partnership, has property that they hold for or on behalf of another entity to be applied for a particular purpose. So that could be, for example, to pay a tax liability. For tax and BAS agents, a trust will generally arise where you receive money or other property on behalf of a client, and so you are then required to keep that money or other property separate from your own money or property. A trust relationship can be created from either an express or an implied arrangement between you and your client. So therefore, it's not necessary for there to be a written agreement between you and your client for a trust to arise. At the TPB, our general position is in the absence of any agreement to the contrary, where a tax or a BAS agent receives money or property on behalf of a client, this money or property will be held on trust and will generally include client tax refunds received from the ATO, any other payments received from the ATO or another entity on behalf of the client, money received from the client to be applied for a specific purpose. So that could be money intended to cover costs and disbursements, could be for setting up a company for the client, or depending on the terms of the retainer, it could also include prepaid fees. So let's look at a quick example to bring this to life. Here we have Simon, and Simon's a registered tax agent. He receives a refund for a client from the ATO. He and his client, they don't have a letter of engagement, retainer or any contract between them that states how the refund should be handled. So in this case, Simon has received the refund on behalf of the client and he keeps his money separate from his own money. And so we would consider that this refund is held on trust for the client. To avoid any confusion between Simon and his client, we would, however, highly recommend that Simon use an engagement letter to expressly set out the details about how the money held on trust will be dealt with. So let's have a look at how you can account for money or property that you hold on trust for a client. Some ways you can account for money or other property held on trust for a client include, as I mentioned earlier, keeping your personal or business funds separate from any trust money, preferably in a separate bank account, keeping accurate and up-to-date records of any dealings in relation to the money or other property held on trust, Seeking prompt instructions from clients about how and where to pay money or other property received on their behalf, and then paying or providing that money or other property to the client in a timely manner. Passing on tax refunds to clients within 14 days unless there are exceptional circumstances or, as I mentioned earlier, some other agreement between you and your client to the contrary. Promptly answering any questions clients raise about money or other property held on trust. And that's another thing we see quite common at the TPB where, they say we're asking our agent, but we haven't heard back about our refunds. So that's an area. Allowing clients access to records relating to the money or property held on trust. Reconciling the trust records and reporting to clients on an appropriate periodic basis, if appropriate. Maintaining up-to-date policies and procedures of the practice in relation to the handling of client monies or other property. And applying money or other property lawfully in accordance with the directions of the client when advising the client, and then advising the client what has been done and when. That list, although big, is not exhaustive, and you can take additional steps to ensure you account to your clients for money or other property held on trust. And what you should consider appropriate steps depend on the nature and the size of your business. And another consideration here is the Accounting Professional and Ethical Standards Board. They have guidance around dealing with client money, and that's APS 310. And this is a standard that applies to members of professional, not all professional bodies, but relevant professional bodies that have adopted these standards. While it's not binding on all tax and BAS agents, it does provide really useful guidance on what steps you can take to ensure that you account to your clients for money and other property held on trust. And the standard requires, amongst other things, that members will be accountable to their client for all client money and keep client money separate from all other money of the agent or the member. Will only deal with client money through a client's bank account or a trust account, and only in accordance with the client's instructions. That members will implement appropriate internal controls and procedures in respect to the operation of a trust account or a client bank account, and will take all reasonable steps to ensure that those internal controls achieve the objectives of client monies dealt with in accordance with client instructions and APS 310. A trust account is properly safeguarded and accounted for, and a client bank account is properly safeguarded against unauthorised access or use. Julie will send you a link to more information on that following today's webinar, because I know there is a lot in that. But right now, let's have a quick break. And Julie, this is a good place to do a poll. So I'll hand over to you.
Thanks, Deborah. As you said, we'll just launch a quick poll. So we'll launch that right now, and the poll will just pop up on your screen in just a moment. And what we're going to do here is give you a multiple choice scenario. So I'll just pop that up on the screen for you. So the scenario goes as follows. We have Angus, and he's a tax agent who receives a tax refund cheque on behalf of his client. He deposits the cheque into his own business account. Angus and his client have an engagement letter in place where the client has agreed for Angus to take his fee from the tax refund received from the ATO. So in this scenario, do you think Angus has complied with his obligations under Code Item 3? So we've got 3 options for you to choose from there, which are yes, no, and unsure. So I'm just going to give you some time to respond to that, and then we'll come back and discuss the results with you. Okay, we've got some people putting through responses, but I'm just going to keep it open for a bit longer to give more people a chance to respond. Okay, we might close off that poll now, and we'll share the results with everyone. So you should see the results coming up on your screen in just a second. But in the meantime, Deborah, I'll hand back to you, and you can discuss the results. So thank you everyone for participating there.
Yeah, really interesting results there, and quite a few people unsure. So really good that we are having this discussion. So in this situation, simply by placing the money into his own business account, Angus has actually breached the code. And that's because he hasn't kept the money separate from his own money. Angus would also breach the code had he deposited the money into a third party's account without the authorisation of the client. Now, really worth noting here is if Angus had deposited the refund into an overdrawn account or an overdraft account, that conduct would be considered even more egregious by the TPB, because by depositing the refund into an overdraft or an overdrawn account, he would in effect be using the money to repay his loan from the bank, and Angus would be regarded as having misappropriated the funds for his own benefit. So that's, something that is really worth, sort of understanding and how the TPB view it. So the next topic I'm going to discuss today is claiming a lien. And let's start by explaining what a lien actually is. So a lien is defined as the right to hold the property of another as security for the performance of an obligation or the payment of a debt. So liens may arise in three different ways: by express contract, by implied contract, or by legal relations between parties. And there are actually two kinds of liens. The first is called a particular or a specific lien. And a particular or specific lien is the right to retain a particular piece of property until the obligation in respect to that property has been settled by the owner. And in most cases, registered tax and BAS agents will be dealing with a particular or specific lien. The second type is a general lien. And a general lien is the right of a particular class of person. So an example might be solicitors or bankers to retain possession of property until the owner of the property has settled all of their outstanding obligations to that class of person. So registered tax and BAS agents will usually not have the right of general lien. However, that question has not been settled by Australian courts. So it's advisable to proceed on the basis that the law doesn't recognise a general lien in favour of tax and BAS agents over their client's property unless it has been expressly granted in writing by the client. So, and that express authority can come in the letter or in the form of a letter of engagement. I want to make it very clear here that a lien is legal in nature. And as such, we encourage you to seek legal advice if you are considering exercising a lien over client property to ensure that you have the right to do so. We also highly recommend that you explore all other options. So, for example, mediation, litigation, to recover outstanding fees before you exercise a lien. And in order to exercise a valid lien over client property, a registered tax or BAS agent must satisfy the following criteria. So you must be claiming the lien in your own right and not merely as an agent of a third person. The lien must be in relation to a debt or a demand due from your own client, and the client must be aware of the debt or demand. You must have actual or constructive possession of the client's property, and the property must have been acquired with the consent of your client. The outstanding debt or demand must be connected to the property over which the lien is being claimed. The debt or demand will usually be for outstanding professional fees or charges. So, for example, the property may be documents such as income tax returns or business activity statements which you've prepared for lodgement with the ATO, and the outstanding fees relate to the preparation and lodgement of those documents or statements. In addition, it's important to know that a lien cannot be applied in the following circumstances. That is, where a client has become bankrupt, or where a client is an incorporated body and its books and documents must be available for public inspection by statute or the company's constitution. What can be subject to a lien? It's widely accepted that registered tax and BAS agents can only claim a lien over property upon which they have expended labour and made more valuable. So, for example, a general ledger, balance sheet or draft income tax return prepared by a tax agent could be subject to a lien. However, a lien would not extend to things like invoices, source documents or POS reports, where those documents are provided to the agent only for checking and do not represent the result of the agent's labour. So who owns the documents? As we talked earlier, engagement letters are really important here to clarify the terms of engagement between you, the practitioner, and your client. The letter of engagement could be useful in terms of a lien, as it may encompass part or all of the agreed terms between an agent and their client, and it could also set out expressly if the agent or client owns documents and under what circumstances. So unless you have stated otherwise, the following documents generally belong to the client, and they will be source documents such as receipts or invoices, correspondence between the ATO and the client, and that includes notices of assessment, letters of advice, tax returns and financial statements that have been prepared by an agent for the client after they've paid for it, of course. And working documents of the agent would not belong to the client unless the client has specifically instructed the agent to prepare those specific working documents. So in summary, unless otherwise agreed, documents provided by a client or another person to the agent for the sole purpose of assisting the registered agent to undertake work for the client, and which the registered agent has not expended any labour or made more valuable, that remains the property of the client or that other person. And in general, those documents cannot be subject to a lien. As we've discussed today, under the code, if you receive money or other property from or on behalf of a client and you hold the money or other property on trust, you must account to your client for that money or other property. So therefore, a tax practitioner cannot use client refunds as the subject of a lien unless agreed to by the client in writing. And I cannot emphasise that enough. In the absence of such authorisation, there is no implied authority for a tax practitioner to deduct their professional fees from the proceeds of a tax refund. So let's have a look now at some of the other important matters that you will need to obtain client authorisations for. And I'm going to start with disclosing client information to third parties. So essentially here, I'm talking about code item number 6. You must not disclose any information relating to a client's affairs to a third party unless you have obtained the client's permission or there is a legal duty to do so. And with changing business practices and advances in technology, confidentiality is such an important issue and one that is becoming increasingly complex. So first and foremost, what is information? Information refers to knowledge that you have acquired or derived about a client, whether directly from the client or indirectly. It's only necessary that the information relates to the affairs of the client, and it doesn't have to belong to the client, and it doesn't need to be or have been directly provided to you by the client. It's a really important point. So who or what is considered a third party? For the purpose of Code Item 6 and under the Tax Agent Services Act, a third party means any entity other than the client and you, the registered practitioner. So that includes persons or entities related to the client or persons or entities related to the tax practitioner. So that could be a spouse or a business partner. Other entities or persons engaged to do outsourced work. So you might have another registered tax practitioner or a legal practitioner or a contractor. Entities within the same service structure, the same trust structure, unless the client is defined in, say, the letter of engagement as the whole structure. And it also includes off-site storage systems. And of course, these days, off-site storage systems could be physical or they could be cloud storage of data. Now let's look at when you can disclose client information. So before disclosing any information relating to your client's affairs to a third party, you need to, firstly, clearly inform your client about the information that you are disclosing, advise your client to whom and where the disclosure will be made, excuse me, and obtain your client's written permission for that. And the written permission may be via a signed letter of engagement, it could be a signed consent or other communication with your clients, as we talked about earlier. It's important to remember you can only disclose information relating to your client's affairs to a third party without your client's permission if you have a legal duty to do so. And if this situation arises, you do not need to seek your client's authorisation. I won't go into too much detail about that, but a couple of examples of that would be, for example, if you received a notice issued under the TASA, if you received a notice issued from the Australian Tax Office concerning, tax laws, or if you received a direction or an order under a court or tribunal, from a court or tribunal. So they're the areas that are the legal duty to do so. Now, Julie will send you more information on this after the webinar, but if you are concerned about your legal duty to disclose, you really should consider getting some independent legal advice. Now, on to outsourcing and offshoring, and what exactly is outsourcing and offshoring? So firstly, outsourcing is where you enter an arrangement with a third party to provide a specific process, a function or a service or an activity. It can involve transferring portions of the services you provide or an entire operation to a third party rather than completing it yourself. And that could be for a variety of reasons, such as capacity management, reducing costs, or engaging specialists. So an example of outsourcing could be contracting or engaging a third-party external IT provider to provide IT services to you. hosting client data on a cloud-based platform. It could be seeking an opinion or advice from a third party, such as another tax agent, or getting some legal advice from a legal practitioner. Or it could be contracting with a third party domestically to undertake specific work. That could be, the bookkeeping, for example. Offshoring, on the other hand, occurs where you enter into arrangement to transfer a process or a function or an activity to a country other than Australia. And it's important to note that offshoring does not necessarily involve the use of outsourcing. So, for an example, offshoring, could be transferring specific work like processing activities from your Australian office to an international office. And, they could be direct employees, no third-party involvement. Or it could be moving an internal business unit from Australia to another country. Again, no third-party involvement. It could be engaging a third party in a foreign country to undertake specific work. Or it could be engaging an overseas third party to host and operate computer infrastructure on behalf of yourself, the registered tax practitioner. So as you can see, there's a wide range there, but it's important to recognise that there are various arrangements that can be a mixture of both outsourcing and offshoring. So let's have a quick look at an example of outsourcing. So we've got here Jackie. She runs a local coffee shop. She engages Tony's tax services. Tony's a registered tax agent to prepare and lodge her outstanding BASs and provide tax advice regarding the proposed sale of her coffee shop. Tony then engages Bella, lovely name, she's a BAS agent, to prepare the outstanding business activity statements. So to send Jackie's information to Bella to enable Bella to do or prepare those outstanding business activity statements, Tony's tax services discloses in its arrangement with Tony's tax services discloses its arrangements with Bella in its letter of engagement to Jackie. Jackie signs it off, and so therefore Tony obtains explicit permission by way of that signed engagement letter to disclose that information to Bella. So Tony, tick, has complied with his obligations under the code item 6 in this situation. And outsourcing and offshoring can be a little complex. So let's do a little poll and see how we went with that. Julie?
Thank you, Deborah. Thank you. I've got the poll up there on the screen now, but once again, it's just a scenario and we're asking you to select the correct response from the list of multiple choice options. So I'm hoping that we have a little bit more success this time. So let's launch that poll. And I'll just give you the scenario and then you can make your choices. So we have VCO, which is a large accounting firm and registered tax agent company. So to minimise its operating costs, VCO enters into an offshore agreement with a data processing firm in Vietnam. The processing firm will perform all the data processing work for VCO's clients. So to send the client's information overseas for processing, what must VCO do? So once again, we've got a few options here for you. So the first one is disclose its arrangement with the overseas firm to all clients. The second one is obtain client's permission. Thirdly, complete a signed agreement with each client, or 4, all of the above. So I'll give you some time to put through your responses. But while you're doing that, I might just repeat the question because we had a few people saying that they couldn't see it last time. So I'll just read it out to you one more time. So the scenario is we have VCO, a large accounting firm and registered tax agent company. To minimise its operating costs, VCO enters into an offshore agreement with a data processing firm in Vietnam. The processing firm will perform all the data processing work for VCO's clients. So the question that we're asking once again is to send the client's information overseas for processing, what must VCO do? So hopefully you've got the poll there up on your screen. I'm just going to have a look and see how we're going for responses. Okay. Looks like we've had about 20% of people putting through their responses, so I'll keep it open for a little bit longer so you've got a chance to put through a response there.
Don't be shy, come on.
And yeah, it does depend on what device you're using. Sometimes it's a little temperamental on tablets and telephones, and also your bandwidth can have an impact on the polls. So hopefully you've got it. But what we might do is just close that off now, Deborah, and thank you to everyone who did get the chance to participate. So Deborah, over to you. We'll share the results again, and you can talk us through what the correct response is.
Fabulous, and it was great to see so many people getting the right answer, because I know it can be quite complex. So in this particular situation, to comply with the obligations under Code Item 6, VCO should disclose the offshore arrangements with all their clients. They should also obtain their clients' explicit permission to disclose the information, and they should complete a signed agreement with each client. So the answer is for all of the above. So, and it's also worth noting here that VCO will have primary responsibility for the provision of the relevant tax agent services, including the data processing work undertaken by an offshore company. So, really important point. So the last thing I'm going to touch on today is managing conflicts of interest, and registered practitioners must have adequate arrangements in place to manage conflicts of interest that may arise as part of activities that you're registered to provide. So Code Item 5 does not prohibit you from having conflicts of interest. And I think that's a really important point, because it does happen in life. But rather it creates an obligation for you to appropriately manage conflicts that may arise and to discuss that with your clients. So let's determine what exactly we mean by a conflict of interest. So a conflict of interest arises where a tax practitioner has a personal interest or a duty to another person that conflicts with the duty owed to the client. And that conflict of interest can arise before you accept an engagement or at any time during the engagement. And a conflict can be either an actual or a potential conflict. So an actual conflict of interest arises where you have multiple interests and cannot objectively and impartially act in any one of the interests. And a potential or perceived conflict arises where you have multiple interests and one interest could possibly impact the motivation to act for another interest. Now, as an agent or a registered tax or BAS agent, you have a duty to manage both actual and potential conflicts of interest, and let's look at ways that you can do that. So when managing conflicts of interest, you should use your professional judgment to determine the most appropriate method to identify and manage a particular conflict. And there's a number of mechanisms that could be used to manage conflicts of interest, including disclosing the conflict to all parties, controlling the conflict, and also avoiding the conflict is also a very valid option. So today I'm going to focus on disclosing the conflict. So where there is a conflict of interest, you should disclose the conflict to your clients, and disclosure should be made at the earliest possible opportunity. It must be specific and meaningful to your client. It must occur before or when the service is being provided, but in any case, at a time that allows your client a reasonable time to assess its effect, and refer to the specific service to which the conflict relates. The form of a disclosure may be sufficient to allow an informed decision to be made about the conflict, may let me start again. If you intend to accept instructions from more than one party in any transaction, it is recommended that before accepting any form of consideration, i.e. payment, you are satisfied each of the parties is aware of your intentions to act for the others and there is consent to act. In addition, if one of the parties refuses to provide the requested consent, you really should consider declining to act for that particular party. And I'll have a look here at an example of a marital breakup. It's something that most agents, are faced with. So here we've got Terence and Sandra recently divorced or separated, and they've been using the same registered tax agent, Craig, for the past 7 years. In preparing their respective income tax returns, it becomes apparent to Craig that Terence claiming a particular rebate would prevent Sandra from claiming it. So therefore, Craig has a conflict of interest because he acts for both Terence and Sandra, and because they also have competing interests in relation to the claim for that particular rebate. So additionally, a perceived conflict may arise regarding one or both clients holding any belief that Craig may not be able to objectively provide appropriate and impartial services to each of them. Craig appropriately discloses his conflict of interest to Terence and Sandra, and he receives a waiver from both parties in relation to the conflict. So in applying his professional judgment, Craig determines the rebate is more properly claimable by Terence. However, Craig also identifies that he's in a position where his duty to Sandra conflicts with his duty to Terence. So in this case, Craig has satisfied his obligations under Code Item 5 because he has appropriately disclosed his conflict of interest and he's obtained permission from both clients prior to preparing their respective income tax returns. So alternatively, if Craig was unable to obtain that relevant permission from both Terence and Sandra, it's unlikely he would be able to adequately manage that conflict of interest regardless of other arrangements that he could put in place. So he should consider declining to act for one or, maybe even both of those clients. And I think it's important to note here that, just because you've been dealing with Terence and Sandra for a really long period of time before they were split and they knew that you were looking after both and each other, that is not express permission. So after their separation, you do need to get that conflict of interest resolved. So I'm going to have a look at a case study here. And in this case, it's a real life compliance case and it relates to the misuse of trust that we talked about earlier. So in this case study, we have a tax agent. He failed to pass on tax refunds promptly to 19 of his clients. And the agent also held the refunds in their personal account instead of a trust account. So our investigations into client complaints confirmed that the agent failed to properly communicate the receipt of the tax refunds to his clients, and they remained inaccessible. So when clients attempted to contact them about the refunds and failed to properly respond to our queries regarding these complaints. In addition to the above breaches, so they were Code Items 3 and 7, it was also found that the agent failed to maintain their professional indemnity insurance as well. So our records showed that their PI insurance had lapsed and they failed to update the board with their PI insurance details despite our repeated requests. So maintaining PI insurance, as you know, is not only a requirement under Code Item 13, but it is also a registration requirement. And the Board Conduct Committee consequently terminated the tax agent's registration. So, Julie, I'll hand over to you. Have we got any questions that have come through?
Yes, I do have some questions for you. So the first one, Deborah, I have is, would I need to review my engagement letter annually if the scope of the work, business entity or fee structures are not changing?
Look, we recommend that you review your engagement letter annually, but if there were no changes in any way to the prior year engagement work, it's okay not to issue a new one.
Excellent, thank you. I've got another question here around trust accounts. So this one's asking, are there any special requirements tax practitioners need to be aware of when setting up a trust account to receive client refunds?
A trust should have its own TFN. So a trust is also entitled to an ABN if the trust is carrying on an enterprise. So I think that's probably the key part of it. So, yeah, if you are setting up a trust account, it's a trust will be, it'll usually say like the trustee for added to the name of the trust, and it's separate to your business's accounts.
Okay, thank you for that, Deborah. The next one I've got here is also about trust accounts. So this one's asking, if a tax practitioner is the trustee of an account, can they also be the beneficiary of the trust?
Yes, a trustee can be one of the beneficiaries of the trust. So for an example, an individual could set up a trust and appoint themselves as trustee and distribute income to their business. However, a trustee cannot be the sole beneficiary of that trust. So, and that is because they will be legally owning property for the benefit of themselves, which is problematic from a legal perspective.
Okay, thank you for that as well. The next one I've got, Deborah, is going back to the topic of engagement letters, and this one's asking if a registered tax practitioner outsources their clients' bookkeeping work to bookkeepers here in Australia and mentions this arrangement in their engagement letter. Is there anything else that the tax agent must do in terms of the Code of Professional Conduct?
No, as long as it's in your engagement letter and it clearly informs your client about the information that you'll be disclosing, advises your client to whom and where the disclosures are going to be made, and gets their written permission. And of course, that written permission can be in the form of an electronic signature. And remember, you are not responsible for the work of another registered tax practitioner. So, you know, that's a little nuance there as well.
Thank you for that, Deborah. I think we might have time just for one more quick question. So this one is looking at fraud and identity crime, and I've got someone asking, how can we avoid fraud through identity crime and ensure that the true identity of the person we're speaking to before disclosing any information? I think this is pretty valid at the moment with doing things online and remotely. So if you could answer that one, that'd be really great.
Yeah, it is very relevant in our current times. So it's important to carefully check the proof of identity documents and to question any discrepancies in information that are provided to you. So you do have an obligation under Code Item 9, which is to take reasonable care in ascertaining a client's state of affairs. So we strongly recommend you perform identity checks for all new clients before accepting them as clients. You know, absolutely. And for existing clients, in particular, if personal information has been altered or information relating to their tax affairs is inconsistent with information that you already hold or previously verified about their tax affairs. And also all representatives of a client. So if they claim to represent a new or an existing client, that you do a proof of identification on behalf of them. And we did have one case, Julie, I know I'm probably going over here, but where a current client went to an agent, but a new employee dealt with them. And in fact, that person's identity had been stolen. And it was out of the norm, but they didn't check it to make sure that they were actually dealing with that taxpayer. So, forms or ways that you can check your client's identity is, you should be checking their TFN, their full name, date of birth, address, bank details, employment details if applicable. So there is a really high risk at the moment, as we all know, with identity fraud, particularly in online environments. And, as you know, I'm an agent as well. And, there are clients that we've never physically met. So, it's really important that we do all the appropriate steps there.
Excellent. Thank you so much for that, Deborah. That was really helpful information. We do actually have some new guidance on this as well, but I'll send through a link following the webinar so that people can look up and read some more information on that if they need to. So Deborah, I just wanted to say thank you so much for presenting today. It was great to hear your insights on the topics, and it was great to see you. So thank you for that, and thank you to Fiona and Daniel for helping out in the chat today. That was really helpful as well. And thanks to everyone for coming along and participating today. It was great to have you all on board. Just wanted to encourage everyone to take a look at our social media channels. We're on LinkedIn, Facebook and Twitter, so we'll keep you updated there with all the latest information on everything that's happening at the TPB. I also just want to encourage everyone to take a look at our TPB e-news. That's our monthly newsletter that we issue, and you can subscribe to that on our newsroom page, which is tpb.gov.au/newsroom. And always, if you're interested in coming along to any more webinars, you can register on our website. Just go to tpb.gov.au/webinars. And you can also subscribe to our YouTube channel, where we do have a comprehensive library of all of our previous webinars. And if you do subscribe to the channel, you do get a notification when we put some new videos up. And the really good part of that is that you can still claim your continuing professional education for viewing those videos. So just before we finish up today, I would be launching an exit survey, and would really appreciate it if you could take the time to complete it. It's really quick, only takes a moment, and just gives us some really good insights into what topics that you might be interested in and things that we can improve on as well to help you get the most out of our webinars. So it will just pop up in your browser, and as I said, it would be great if you could complete that. So thanks everyone for joining us today, and we do hope that you enjoy the rest of your day. Thank you.